Great. So YouTube is now up and running. Late, but because of technical difficulties, but up and running. All right. So welcome, guys. Welcome to this yet another um, live stream from yours truly, Jermaine Dunn. This is the channel Dunn Audit the Law, and tonight's topic is going to be focused on um, search of property and the law governing search of property, because I have heard several people having issues with even having issue with members of the Jamaican Conservative Force, just dipping into their pockets or dipping into their cars and just combing through, wanting to go into their phones. So that will be the main topic for tonight. Again, welcome to the faithful many who have take the time out to be here. Um, do don't be afraid to share this live. We are streaming at the same time, both on YouTube, just live on YouTube, and we are here live on TikTok, Don't Audit the Law. So, as per usual, I would like to start by taking us down memory lane on things that we have looked at in the past. Now, some of you might be saying, Mr. Don, why are you coming back and reminding us about this thing? I keep reminding us about the ruling in the Court of Appeal on the 15th of July. That was the date of the ruling, 2024, where the court has set a new precedent that equitable treatment by a public body in the execution of a function is a constitutional right that is no longer dependent on there being inhumane treatment by the public body in the execution of any function. Welcome to those who are on YouTube. Now, that is imperative, viewers, subscribers, because as far as I am concerned, I know my voice is a bit hoarse, lot of talking. As far as I am concerned, that ruling should have caused shockwaves, but from Parliament go all the way around. Shockwaves, but you hear nothing of it. Such shockwaves because when the court ruled that our right to equitable treatment by a public body is no longer dependent on the right to humane treatment being violated at the same time, then that means, viewers, that the laws that are currently on the books, there must be regulations in place to ensure that these laws prescribes detailed procedures under which these powers are to be executed. If not, viewers, take it from me that it means that the law is likely to cause an infringement on your constitutional right to equitable treatment. Remember, we said equitable treatment means being treated fairly. Equitable is synonymous with being treated the same way. Well, again, viewers and subscribers, I repeat for emphasis, that ruling should have caused shockwaves through the legal system. Such shockwaves like the 5.2 and 3 and 4 magnitude earthquakes, and even harder. Yes? That our parliament, for example, and our authorities, our local government bodies, should be looking at their laws and saying, hey, if these procedures are not, if these laws don't have regulations which prescribes the procedures under which these discretionary powers are used, then somebody like me, yes, can approach the court. The Supreme Court is the favorite, and ask the court, pursuant to Section 19 of the Charter of Fundamental Rights and Freedom, pursuant to section 19, that the law is likely, now, infringe a right, it is likely to cause an infringement on our constitutional rights. Think about that for a second. Again, I repeat, one of the repercussions of such law or such ruling from our Court of Appeal is that if the laws that gives the powers to any public body do not have regulations that prescribes how that power is used, then it means that it is likely that some people will be treated differently than others in the same situation. And therefore, so long as there is the possibility or the likelihood that different people in the similar situation can be treated differently, then that is grounds for the court, unless the state can prove that that law is demonstrably justified. And again, we have dialogued here in this forum that I have not seen the state being able to prove any law demonstrably justified in a long time now, for years now. So unless they can prove that, then the court, the constitutional court, can strike down every single piece of law on the book. Think about that. And I'm not talking about specifically any RTA. As long as it is likely, based on how it is written, the law and the regulation, to cause an infringement on the right to equitable treatment, then a man have a case to present before the Constitutional Court. So again, I continue to emphasize this position. And for clarity, for those who are joining us for the first time, and those who have been with us from the beginning of these live sessions or live streams, that I have made it abundantly clear that the law, which is the common law in statutory interpretation, is that where there is a more specific law, a general law is not the law. Where there's a more specific law, the more specific law is what takes precedence. So, I say that to recap again on last Monday's discussion, whereby we looked at Section 91 and Section 20 and Section 7 of the RTA 2018. And we compared those two sections. And in comparison, viewers, I made it clear to us, we're all here, that Section 91 of the RTA 2018 is the section that conveys the power of a constable to stop, save and except when there is reckless driving and all of those and some other things observed. It is Section 91 of the RTA because that is a specific law that gives the power to stop. Justice David Batts from the Supreme Court in 2013, though there is a new Road Traffic Act, the same provision, in other words, the same wording of the Section 58 in the 1938 Road Traffic Act that was repealed by the now 2018 Road Traffic Act. That provision was interpreted by our Supreme Court in the case of Hemans versus the Attorney General. I know many people are trying to discredit Hemans versus the Attorney General and say it is no longer the law because there's a new Road Traffic Act. But such people are clearly unaware of what common law means. In layman language, common law means law that applies to one applies to all. And until and unless Parliament pass a new law which changes, and it has to expressly attack that common law provision and say otherwise, then anything that was interpreted by the court, and I want to remind viewers who look at Hemans versus the Attorney General 2013, that the judge did not interpret Hemans versus the Attorney General based on just the Road Traffic Act. His interpretation came from the Constitution. And the Constitution from then is the same elements of the Constitution now. So when people like to say, oh, Hemans versus Attorney General was from 2013, and here is a new Road Traffic Act, I remind viewers that in paragraph 58 of Justice Batt's ruling, Justice Batt made it clear in that case that section 58, which gives the power to stop vehicle, direct traffic, blah, Justice Batt made it clear. That section, which is now the section 91, gives a power to stop the direct vehicles and for some reasonable purpose. And reasonable cannot be overstated. Reasonable, fair, logical, justified reason. To ask a person in a free and democratic society, viewers, to put out your hand and stop them driving a white plate in a free and democratic society, to stop and demand that they produce their documents and driver's license just so, cannot be demonstrably justified in a free and democratic society. Keyword, democratic and free. For any of us who take the time out to look at, to do a Google search and check the meaning of free and democratic, democratic society is a society governed by laws, which means what is not in the law expressly, you as an individual can do otherwise. Let me pause here. I'm going to pause here. Give you some time to reflect. Go Google search, go do some look, do some check. This is not propaganda machine. This is a factual platform. Only facts come here. And if I ever make a mistake in my statements, I'll be the quickest to correct them. Let us proceed. I see you, Ren, on YouTube. So what I said a while ago, gentle people, in a free and democratic society, free and democratic is clear language. Free, meaning you're not slaves, you're not bound to any master, you are allowed to do what you can do, but the democratic part of it says, by law, within the confines of the law. Because a democratic society is a society governed by laws. It cannot be that in a free and democratic society where a people has the right to move freely throughout the country, the state, through its agent, through the corporation, the JCF, is going to tell someone like me that when Nanan go up, I must stop for a random stop to check my documents. That reminds me of an autocratic society and not a free and democratic society. I understand the rationale from constables as I'm conveying to you. But I'm saying, if a constable stopped me to check my documents, he's not trying to check my documents for nothing. Such power to stop is an aggressive power because it infringes on the right to move freely, etc. So when a constable decides to step out in the road, put the hand flat, signal to go left or right in a stop signal, the constable is using a coercive power. He's showing dominion over me. He is infringing on the right to move freely. To then do what when him tell me says a random check? To see if me commit a crime, because that's my check license for. Because if the constable wants to get my license and see that it is expired, no chat, no pre, no, a straight ticket in most cases. So when people are saying, just show your documents now, just stop now, just comply now, if you have to stand on your rights or you lose it. The only people that don't have rights are slaves. That's the only thing you have to stand on. I was having a discussion yesterday, and someone in that discussion, it came up. The person said, the Constitution preserves our rights, you know. The Constitution not give the rights. It preserves the rights. So your rights are there, but you have to activate them. Because if you don't activate a right by asserting them, you waive them. Yes? So you have to activate your rights. The Constitution preserves your rights, but you have to activate them by making it clear to the state that you are standing on your rights. Just like when in Christianity, where they say, standing on the promises of God, my Savior. Yeah, for example, you have to stand on your rights. So, again, as I move forward to the main topic of the night, this is a recap. I'm saying to us that the coercive power to stop, when a constable is telling me that they're going to stop me, for example, just randomly, out of for no reason than to check if my documents are in order, then and me know to the bottom of my heart say, I can't friend him a look. And I check him and ask if he check them. So that they can say, hey, it expired now. You should go renew it tomorrow. That not happen. It's expired. 30K ticket. If that's the amount. You remember the amount. Oh, you don't have fitness? Oh, you forgot to extend it less yesterday? Oh, there's a $900 million budget plus. That needs to be filled. 30K ticket, if that's the amount. So, don't blame me, those of you out there, who when I stand on my constitutional rights, because it's the only thing me got to stand on, my rights, I have to stand on those rights or I lose them. And you see, when me assert them now, here how the money game work now. Yes? Here how the money game work. You give me a 30,000 ticket and you discover that by breaching my constitutional rights. Remember me tell the state, say for example, and its agents. The agents are going to cost the state. Because me now pay a ticket to breach my constitutional rights. I'm not going to look back my compensation for the breach. And me no have no ticket. We're getting value more than what the court are going to award me for my breach of my constitutional rights. So I'm saying to the members of the JCF, stop violating people's constitutional rights. Because at the end of the day, it can cost the state far more than the amount that they're trying to collect through the budget. That's a fact. Look at the latest case with the tickets that were issued in violation in terms of the amounts. The award for the one count of breach of constitutional right was $250,000. There were no aggravating factors. Plus the guy got legal costs. Yes? So let's imagine if on every count, if several constitutional rights are breached during that encounter, then if it's several constitutional rights that are breached in that encounter, viewers, you can claim compensation for all of them, and it adds up. But you have to assert them or you lose them. That is how the game is played. So when some of us see me go like being like, here, I have the documents, I hand them over. The right is already infringed. But I assert it. I have 6 years to collect. It's a money game. State a look money, the ticket. Me a look, me a go take back the money for breach of rights. Simple. That's just how it goes. That's how it works. You know what's the worst thing can happen to the state in traffic matters? If everybody go to court to defend the tickets and decides that I make everything go trial, oh God. They're going to tell us that the judge might say to you, you know that if you go to trial, we're going to be able to charge you more. No problem. My rights are violated, so the more way you can charge me, no worry. Me going to just make it cost the state more. Because going to trial require the clerk of court to take up more time doing research, require the entire system to spend more money to try to collect the amount that they can collect from you. And at the end of the day, you counter claim, right back for your amount of money. Yeah. I remind us that nothing that is said on this channel or on this platform constitutes legal advice. Everything here is for information purposes only. Mr. Dunn never tell if we do anything. So let me make that clear. Nobody else say Mr. Dunn tell if we do it. Because Mr. Dunn, me know you have some people on your wait, you know. Nothing I'm saying here constitutes legal advice. I continue to repeat, like I said the last time or the time before that. If you need legal advice, there is a procedure for that. You go into that attorney's office, you sign your papers, and you present your case, and you obtain legal advice. Everything that is said here is for general information purposes only. The author of this platform has made every effort to ensure that the information conveyed here is an accurate reflection of the law. Let's continue. So, it's imperative, viewers, on both platforms. It is imperative that you understand that your rights are preserved by the Constitution, but they must be activated in all encounters. If you don't, you have waived it. Yep. That is it. So again, in closing for this recap, when constables who are on any of the two platforms right now, I'm saying to you specifically, go and Google. Just use Google or any of the Bing, any of the Yahoo, whatever of the search engine you use. Use our ChatGPT. Ask the question. Ask. Does a more specific law takes priority over a general law? Ask that question. Also ask this question. Is the common law law? Also ask this question. Though Section 20 of the Road Traffic Act 2018 says that a person who states that a person who is driving a motor vehicle on request by, basically, I'm not quoting from the statute, I'm just saying what it says in general. Says on request by a constable in uniform or one who shows his ID, I'm going to remind some constable, because I say, well, them stop me a while. If you only have a name tag and you're below the rank of inspector and you don't have a badge number, you're not in uniform. And if you don't give me license, come on, guys. You don't have no legal grounds to give me no freedom to produce. Because the uniform below the rank of inspector is badge number, name tag. If you have on the, depending on this uniform, if you're wearing the standard issue, general issue uniform, yes, that all police wear, whether it be rural or constables on the Constable Force Act, the cap, you know, the all of that is a part of the uniform. So if it's not there, you have to show those IDs. The IDs want to know want to show. Because I'm afraid we show no one name. Yep. So viewers, as I said, Section 20 requires that it gives a power to a constable. It says, on request by a constable in uniform or one who showed their ID, your you are to produce your your driver's license. And section 7 says the same thing about the other documents. But I say to us all in clear language, let me know after this if you get it again, that section 20 and section 7 conveys no power to stop and request documents nor driver's license. When Parliament wants to do that, Parliament use clear language. Parliament did use clear language when it conveyed the power to stop. It used it in section 91, which gives the power to stop vehicles for the direction of traffic or some reasonable purpose. And on says so. Is Hemans versus the Attorney General. The court or Supreme Court said so, not me. When it says so, in a 2013. Somebody said, no, Mr. Don, but this is a 2018 law. And you talk about 2013. The same provision, in other words, the same wording of the section will give the power of stopping at the law there, are the same wording used in the one year. Not change. So at the same, anything the judge said then, I see anything apply now. So the power to stop is under section 91 for general purposes. If it's reckless driving or so on, it's other sections. That's where the power comes from. Because a more specific law takes priority over a general law. Anybody who can disagree with facts and arguments. But what I present here is the law, not from my head, from the Supreme Court. And the court went further to say, not interpreting the Road Traffic Act 2000, the old one. The court made it clear, viewers, that the request for documents and driver's license comes under the similar circumstances under search of person and other properties. It is said so in section 58. Gentle people, for those who are seeking clarity, let me give you something else. Law is not just what you see on paper. When you read a statute, you have to interpret it in both layman and in legalese. It's written in two types of language. Sometimes there's even Latin, which is a part of the legalese, used. Or is Latin is there that you not see. There are some dictas that form law that is not written in those statutes because they don't have to put them in there. Sometimes the Parliament codifies the common law. Like when Parliament say in a clear language that you, me, can sue a constable under section 33 of the Constabulary Force Act for taking any action maliciously or without reasonable probable cause. Which means, for interpretation's sake, my naysayers, the people who are here not to learn but are here to try to cuss Mr. Don, who are afraid to listen because they're trying to take a power that they don't have. I am saying to you that there's no law, Road Traffic Act nor otherwise, that section of any law that contradicts section 33 of the Constabulary Force Act, which stipulates a condition under which a constable may be sued for taking any action without reasonable or probable cause. What that mean? If you stop a vehicle and you never have reasonable or probable cause, and for those who are not understanding what reasonable or probable cause means, I will repeat for emphasis. It now means you can't come tell me, say, under the guise of public safety, I'm going to stop your vehicle. Nonsense. That is the intent of the statute. When the statute conveys these powers for public safety. But they can't stop me and say, oh, for the purpose of public safety, that is my reasonable cause. You want to slap with a textbook and get the language right in your head. Yeah? So, there is your reasonable probable cause has been defined. It's not in any statute. The definition is not in a statute, but it is in case law. What does the definition say? It says reasonable probable cause means an honest belief in the guilt of the person founded on reasonable grounds that that person is probably guilty of an offense. There are hundreds of case laws that interpret reasonable probable cause. And I said in our last live that the powers of a constable are defined under section 13. The duties of a constable. The duties, powers and duties are different things. So the duties of a constable are defined under section 13 of the Constabulary Force Act, and also for the district constables under the Rural Police Act, the one. Yes, that act. I don't remember which section. And if you read the duties of a constable and tie it into section 91 of the Road Traffic Act, you'll hear this. In section 13, it says, the duties of a constable is to keep watch by day and by night. Oh Lord, those words. To detect crime. So keep watch by day and by night to detect crime and some other things, like, and to find those who he has reasonable suspicion to have committed an offense. You all can see it. So what that mean, viewers, to keep watch? The duties of a constable is to keep watch, not to go and abuse and people and stop them randomly. You are to look for the crime, keep watch by day and by night. Yes? Look, smell, hear, taste. Use the senses by day and by night to detect crime or to apprehend people who they have reason to suspect that they have committed an offense, so on, so forth. And I miss so at the enabling statute that created the force. Say so. I know me. And as far as I know and understand statutory interpretation, the statute that gave rise to the creature of law is priority statute. Everything else is secondary, because that is the statute that gives birth to the creature. So the statute is clear that the duties of a constable is to keep watch by day and keep watch. Not to see you coming now, do not and just decide to me go activate some power. I don't miss it so at the statute. So now tie that into section 91 now. We say of the Road Traffic Act now. We say that the driver of a vehicle, not a motor vehicle, but a vehicle, that means if I drive a donkey, if you are driving whatever you're driving, yes. If you're driving, you must obey all directions given by a constable too. I'm going to include something in that now, because no attorney, for example, no lawyer, no person, no student of the law can come here and say, Mr. Don't tell a lie with this now. And if you're on here, tell me it's a lie, Michael. This section 91 of the Road Traffic Act says a constable, and not the exact words, but these are the key words. A constable, in the execution of its duty, may direct any vehicle to stop, and the driver thereof must stop. You know what it says? Direct any vehicle. You know, say even though the word reasonable not in there, any court, because I've seen case law, those who need the reference for your purpose, if you don't believe me, ask me. So just remember the reference right now, but I have them written down. I have seen case law where the court has said, or the Supreme Court has said, any power given to the police, all if it just says suspect, nothing will have to do with police power, can't be just mere suspect, even though that is what the statute says. It has to be reasonably suspect. So therefore, using those statutory interpretation, guidance as given by the court, our Supreme Court, then if the power say, if the law say that any directions given by the constable, it must be reasonable directions. So even though you see the word reasonable in front there, no power given by the police can be exercised unless it is reasonably being used. That is a part of why in Hemans versus the Attorney General, viewers, it has been said that the powers to request documents and driver's license must follow similar cause, such as reasonable suspicion of an offense or reasonable or probable cause. So again, even though it says must obey all directions, and then it lists out the directions under section 91, to stop, to pass, left or right, you in statutory interpretation, no, not plain layman interpretation, legalese now, using legalese in the interpretation, because this is a power given to the police, our very Supreme Court has said that no power, so even though the statute might say suspect, mere suspicion is not enough. It must be reasonable suspicion. My thumbs up if you're following. My water break time. As we're going today, we're building into the main topic for the night. Thumbs up if you're following, guys, and don't be afraid to share so others can jump on here. Share, so many people can jump on here. Don't be selfish. Don't be selfish now. All right. J964J. I know we have been debating on other posts, not my posts. All right? But those arguments, Jay, which I can address at another date. But briefly, yes, you have a license. And people that try to bring the argument to say people are volunteering. I'm just gonna address Dre right now briefly, gentle people. They're saying one of the arguments you have is that people are volunteered into this licensing stream. And I say, bull. Read the law and you will see. No, you don't have no option. Parliament say if you not get a license before you drive, it's an offense. How is that volunteering? Parliament made it clear if you drive a vehicle and you don't have a license, it's an offense. There is no volunteerism there. It's pretty much as good as a gun at your head. Yes? It is almost Parliament. It's almost, me never saw so, that Parliament put a gun at your head and say, hey, do it. And if you don't do it, you'll go to prison. How is that volunteering into the licensing scheme? Come on, guys. We must use some an army try to show the logics. It is not volunteerism. If you're told you don't do it, because ignorance of the law is no excuse. So you read the law and the law says if you don't have a license and one of the agents such as the JCF, Constabulary Force, catch you, then it's a criminal offense. In fact, if even they catch you, it's a criminal offense and you'd have committed a crime. So how is it that if somebody got a license, they are volunteering into it and agreeing to the terms and conditions? Yes, they didn't volunteer into it. They were forced into it. They don't need to put, like in the US, under threat or UTC, for example, or under threat and duress. No, because the law is clear. You don't have one, you're a criminal. So you take your cue from that and move, go get one. There's no volunteerism into the licensing scheme. Don't get me wrong, I agree with licensing because you ought to have competence on the road. Because the intent of the statute is for public safety, and the public must be kept safe. But we have to also remember that this is a free and democratic society. There is nowhere in the statute that gives the police on the Road Traffic Act I'm talking about, that gives the police a power to stop, an express power to stop just to check if someone's license are up to date. That would be to give the police a power to be judge, juror, and executor. That would give the police a power to determine guilt, for example. Hear my logic. If I need to prove that I am not guilty to the police, what could I law could I go so? That would be spitting in the face of the Constitution that says everybody is innocent until proven guilty. Are you telling me, Jay and the rest of the people who are following that argument, are you saying to me, Jeremy and Don, and the wider Jamaica through your comments, that the people are not innocent until proven guilty, but instead they are guilty until proven innocent? And so because it is a crime to not have a driver's license while you're on the road or driving, yes? It's a crime to drive a vehicle without being issued a driver's license. And you're telling me that I am to then, the law is giving the police a power to infringe on the freedom of movement by stopping the vehicle, thereby stopping you, to request your documents, to prove to the police that you are not guilty of a crime. Just think about that 1 second, man. Where is it that where did the court, under the court, determine guilt or innocence? So we must prove to the police I'm not guilty of driving with a driver's license. So in the right one ticket or arrest me. Him need for do real police work. That is the sound of a Nazi state. Jay, screw it in your head. What you are presenting is to say that this is not a free and democratic. All right, Jay. Here me go done now. And the others. Here me go finish up. I'm going to use Justice Bat's words. 1 second. I'm going to give you a second to reflect on that. Just give it a second. Drink some more water. All right, so let me use Justice Bat's words. Which Justice Bat was not interpreted in Road Traffic Act when he made that. So when you want to come tell me about Emans versus Attorney General, for example, is not law. Yes, communist too, Chad. When you want to tell me about Emans versus Attorney General was from 2013 and it's not the reflection of the law, you and your brain want some screwing. So you can understand exactly what I want. Justice Batts used these words. Hear me out. It's paragraph 7 of Emans versus Attorney General. He said, while love, and this is the last paragraph of last sentence in paragraph 7 of that judgment. He said, while lawfully driving his motor vehicle, the claimant was entitled to ensure that there is respect based for his freedom of movement, or that his freedom of movement will not be infringed on without lawful authority. I'll repeat, I'm not using the exact words, I'm going from the top of my head. But you can go look at it and say the same thing I said. While lawfully driving his motor vehicle, the claimant, which is Mr. Emans, was entitled to respect for his constitutional right to freedom of movement and essentially guarantee that those rights would not be infringed on without lawful excuse. What that means? Even the court recognized that driving is one way in which freedom of movement is done. Come on. The court is the interpreter of law. So who are you to tell me so what the court says not so? If you believe the court is wrong, you have an option. Go to court, file a claim, and go see if you can change that common law provision. And no, otherwise, you're just telling me your opinion, And even my opinion don't matter once the court rule. The only way my opinion can become the law is if I go before the court, and make a statement, present a case. I want to present the case and the court agree with my position. Okay? So, the next critical thing that Justice Batts said, and I want you all to listen carefully, viewers. Justice Batts said, this is on towards the end of the judgment in Hemans versus the Attorney General. He said, the people in this country are still under the Queen's peace. Anybody on here who know that, who read that judgment? But no, we're under the King's peace. But I can use the words there. Are still under the Queen's peace. And so being under the Queen's peace are under no obligation to carry a pass. Sir, may I address you and others? You know what under no obligation to carry a pass means? Me no need to stop an ID. This is not a driver's license, is an ID, you know. You're asked me to stop and identify myself. That's what you're doing. You're stopping and IDing under the disguise of some other things. Come on. Come on. Why can't I screw to your head? Yes, I'm trying very hard here. But some of you just want to hold on to the foolishness and understand the constitutional provisions. But tell me about what they plain reading when law tell us say. I acknowledge the constables have a power to request documents. I acknowledge there's a power to stop for the direction of traffic and for some reasonable purpose. But to stop a man just to see if he have driver's license, I not suspect no crime, I not here saying no have none, I not that is not a reasonable purpose. Yes? That's not a reasonable purpose. And I remind you, sir, and the audience, that in the words of Justice Batts, this wasn't the Road Traffic Act that he was talking about when he was saying this. And the court says on me. And that is a part of why it is still the law. Yes? In the words of Justice Batts from the Supreme Court said it. What did it say? Nobody's under any obligation to carry a pass. And when you stop me randomly driving the vehicle, you're asking me to show you my pass. And a miss says so. And the High Court says so. The court, which is the interpreter of all statutes. And anything them say statute say, a so it go. And that is the common law. And if you want to change that, you have to go fight your case yourself and make them buy into your position. But until then, I will hold on that since I am currently under the King's peace, then I am under no obligation to carry a pass. And I say so. And the court says so. And if the police are respecters of the law, then they will know that the court's judgment is the law. Anything the court says the law is the law. Finally, when Justice Batts was interpreting and ruling in Hemans versus Attorney General, when the same constitution provision is still in effect right now, was in effect then, not changed on the part there, Justice Batts made it abundantly clear that our foreparents had fought hundreds of years for our freedom. And our constitution gave us that freedom of movement. He recognized and acknowledged that while lawfully driving his motor vehicle, that means him having license and everything, he was entitled to guarantee that his freedom of movement would not be infringed on, except with justification. And that's lawful justification. So when I say it, this is not just about the Road Traffic Act. This was the court interpreting on the Constitution and telling me, as a Jamaican, that I am under the Queen's peace, but now I'm under the King's peace, and I am under no obligation to carry a pass. Yes? So, who not like that? phone business. Just remember, reasonable or probable cause is necessary. Not tell me about no. Not tell me. Listen, we're talking about law and not feelings, okay? So don't tell me about the police. You surrendered into the regulatory enterprise, and so you agreed to be regulated. Yes, but I don't see anywhere in the agreement that says the police have the power to stop me at random to check if I am compliant with the Road Traffic Act, or to check if my I have license. Not no go, sir. For him to do what? Remember, somebody can fail to produce. You remember that? You remember that? Guys, you remember that you can fail to produce? And there's a charge for that? You can. Anyway, let's move on. All right, so then. And all right, so answer the question on YouTube. The FLA, that's NS. The FLA tell you that you have to have your documents when you are carrying the firearm. All right, I'm going to address that. Let me address that now. Let me show you the distinction between the firearm and driving. There's no right to bear arms in Jamaica. None. None. There's no right to bear arms. That's not a constitutional guarantee. So, since there is no constitutional right to bear arms in Jamaica, then the authority to carry a firearm comes from statute. As a result of that, you can't claim any infringement of the right at that point. Because if you look at the statute now, it says several things. That's the Firearm Act 2022. Yeah, I believe. Firearm and Prohibition Act. Carrying a firearm is not a right. It's not a constitutional right. It is a privilege granted expressly by statute. There's no right to bear arms in Jamaica, unlike the US. So the government can regulate firearms anyhow they want. Will you get it? There's no need for them to have any demonstrably justifiable grounds, because there's no right to know a firearm. So anything they say. But we have to remember now, because when you are driving a vehicle or you're walking, then and you're carrying the firearms, so hear me carefully, and you are stopped, then the freedom of movement is infringed on. As a result of that, in every encounter with the constable, the law says it must have reasonable cause to suspect. Get it? And every statute them put them words in there, but it don't mean say you have to actually, have to have reasonable cause. So when the police is going to, if them suspect that if they want to search for a firearm, then the Firearm Act, in addition to the Offensive Weapons Act, says they must have reasonable cause to suspect that you're carrying a firearm. And we have spoken about this already. They must have more than one hunch. I know me say so. Anyway, we're not going to go down on firearm today. But like I said, once you are stopping someone, movement, you're infringing on the freedom of movement. And that is why the statute recognized that. And the drafters of that statute, and then the same somebody write every statute, yeah, found it important or prudent to put into it reasonable cause to suspect. They never put it in the Road Traffic Act when they put search for documents, because they don't have to. They don't have to. And it's just how different people draft different statutes. Firearm look more serious, act more serious than the Road Traffic Act license. So one drafter might tell themselves, sure, but now put their word in there for whatever their motives were. But the Parliament recognized firearm is not a constitutional right, but moving freely throughout Jamaica is a constitutional right. So once the concept is going to stop you to check if you have firearm, then there must be reasonable cause to suspect. Whenever I watch a show Reddington it, when Raymond Reddington in Blacklist, when that episode, when the policeman feel like say, and Reddington beat the case because the officer was like, he who had a reasonable probable cause, the suspect that he had a firearm. And Reddington was like, me? Me? Somebody like me? You would think that I would make any foolish movements with somebody like you? Can suspect that me have a firearm? No, sir. No go, sir. As somebody tell you that. Or something else. Yeah? So, but it's not just an hunch. It's more than that. It's more than a hunch. It requires more than a hunch to have reasonable cause to suspect. Reasonable suspicion is where it appears that crime has been committed. I repeat this again from a previous live. If it's information the police receive, that information need to come from a credible source. Okay? If it is based on observation, then it's things like him observe a bulge in your waist and them things there, you know? Some things like those. Anyway, we're not talking about firearm today. We're on the matter of search of phones. So let's go into that now. Now, your phone. There's no statute in this country that I have seen. But let's take a break. We're going on the topic of search of your phone. We're going to take a 1 minute break, and then we will return. So in the meantime, you can go get some water or something, and send some thumbs up so I know you're actually following what's going on and that you're understanding what's going on. Send something here. Welcome, Jerome. I see you, Jerome. It's Jerome Barrett. I see you. Send the thumbs up, guys, so I can know you're actually following and understanding. I see them coming on YouTube. See one there. All right, send them come. That's how I know you're here and you're following. All right. So we'll continue in a few. For those who are just coming, we'll continue in a few. It's a little water break. I see the person who said, tell us about VCP. I see a question. I'll definitely tell you about it in this discussion. All right, let's roll. Ready to go. Okay, so the main topic for tonight, as I said, is we're going to be looking at search. The question is, can the police search your phone? That's the main topic for tonight. And then we will allow for as many questions you have, and I also allow for others to box in. All right. Now, can the police search your phone? I'm going to use the question that was asked here about VCP to just lead right into it. What is a VCP? I had a live here, I think it's a week ago, where I outlined elements of the police public interaction policy. And in that policy document, under the topic, under the heading, stop and search, it states in clear language what is to be done, or the protocol, the procedure is to be followed. I think it's item 3 on that list of the protocols in a stop and search. It says the police is to say to you that they are conducting a vehicular checkpoint. After that, the next thing they're to do, well, it doesn't have to be in that order, but what they're to do is to tell you that if they're to explain, that's the words the public interaction policy says. They are to explain the reason for stopping you. Now, going back to the word vehicle at checkpoint. If you look at the police interaction policy, it says tell the person you're doing a vehicle at checkpoint or you're conducting a vehicle at checkpoint. And then the next thing you have to do is you have to explain the reason for stopping them. That alone tell me, say the JCF understand that a vehicle at checkpoint is not a reason for stopping anybody. Me are looking at the eyes. Me not even reason law and logic, you know. That alone tell me, a reasonable person, that the JCF knows that a vehicle at checkpoint is not a reason for stopping anybody. So when you stop somebody like me now, and go tell me, say, when me ask why reason stop me, I'm conducting a spot check to the vehicle VCP. You not know, sir, run up in our lawsuit. I run up in a 250,000 plus debt. You just cost the government 250,000 plus. Yeah? Blessing LJ on YouTube. So, I'm laughing, guys. It doesn't mean that everybody who knows law, you know, run go sue for everything, you know. But I'm just saying, you can. It's the most heinous ones you sue for. Yeah? The ones that, when they may try to prove a point, you can't, hey, the Supreme Court pack, you know. It pack all 10 years. You see how long cartel take to get, just, it's an example of how packed the system is. It takes a while to actually move your way through the court system. It takes a while. Okay? So, VCP is a name of an operation. It is not the name or the reason for stopping you. It is a description of the operation that the police is conducting. Now, I've read in a case law. It's a case of, hold on, don't say anything. Hold on. I think I have that one written down somewhere close by here. Just hold on. It's the case of, where is it? Where is it? Where is it? Where is it? Andy Davidson versus the Attorney General, 2021, JMSC CIV 37. In that case, I repeat, Andy Davidson versus the Attorney General, 2021, JMSC, that means Jamaica Supreme Court, CIV 37. I've already mentioned in previous live what does CIV represent. Now, what is important for us to understand? In that case, what the court was looking at is a situation where the police stopped somebody. And, you know, the court was saying, well, the sergeant testifying was saying that they were conducting the VCP. The Supreme Court said, well, I understand the VCP to mean that you're acting on intelligence. So you're not out there to stop people randomly. You're out there acting on intelligence. So if you're doing a VCP, it's because you're acting on intelligence given. Yeah? So when you're out here and they say, oh, may I do a VCP and we're out here standing, and then I'll confess to you that them stopping people randomly, then that's no VCP. Then right now, I never know what teach. Yep. Yes, bigger man, spot checks are illegal. Not for, but at least at the very least for white plates vehicles, private vehicles at the very least. And I said I will have a live session where I will address the red plates and the green plates, the taxis and the carriers. I will address those separately, not in this live. Yes, you will see the announcement based on the topic for the live as I post them. You can always pre-register for it so you can see those who are interested. Continuing. So, VCP is the name of an operation. It's not a reason for stopping a vehicle. And if I use the words of the court, when the court was analyzing the words of the testimony from the sergeant, in that case of Andy Davidson versus the Attorney General, 2021, the court said, well, if you're saying you're doing a VCP, I take a VCP to mean that you're acting on intelligence. Yeah? And that's it. So that is the name of the operation being conducting vehicle at checkpoint, which is checking for something based on intelligence. Okay? That is what a VCP should, at least should be. A VCP is not the reason for stopping. Well, sorry, I'm not going to say the VCP can't be the reason. If that is the reason the police give it, then that is the reason. You just know, say you just a smile all the way to the bank. If you go find a lawyer, yeah, with him name and him badge number, all right? Smile all the way to the bank. Now, the VCP is the name of an operation. The reason, now, after, if you look at the public interaction policy again, under stop and search, it says that after they say that they're doing a VCP, they're then to explain. And I miss so. And the public interaction policy will say anybody, any constable who violate the procedures set out herein will face disciplinary action. And I miss so. The interaction policy. Okay? Don't say me that don't say. I mean, I don't listen to messenger. Anyway, so the next thing is to do is to explain the reason for stopping you. Lord have mercy. English language can't get no plainer than that. Explain means in detail provide your justification for stopping this Abuaya vehicle and, for example, not that one. Well, not to say that one, but you know. Provide the justification, yeah, for doing that. The spot, this, I mean, Chadwin, I'm seeing your question. Spot check. The policy recognize it, but at the same time, what I'm saying to you is this. The policy says it's the name of an operation, but it does not form the reason, Chadwin, and everybody else, for stopping you. Follow me? So, yes, spot check is the name of an operation, and it's an operation on an operation, but it cannot form the reason for stopping you. Yeah. How Justice Bat's ruling looked at spot checks is when constables said they must stop on the spot and check you for documents and driver's license. That's the element of spot at random. That's what Justice Bat, as far as I understand, is saying that is unlawful. Stop you on the spot to check if you're to check your pass, to check your ID to see if you are a licensed person. You know what I can't understand with the police also? They never recognize it when them stop the vehicle, private or otherwise, and I ask the driver if they identify themselves, etc. That if passengers are in there, that they are also infringing on the rights of the passengers to move. I don't know if they don't recognize that. I don't know why they don't recognize that. And unless they have a lawful justification to stop the driver, then nothing will make sense for them depriving the passengers of their freedom of movement. Hello, we can go on this over and over again. Continuing though. Now, so let's say a vehicle at checkpoint is the operation that is being conducted by the police. Then the question is, does the police have the power to search your phone? My answer is this. The Charter of Fundamental Rights and Freedom, from section 13 outlines of the Constitution, and people, please don't be reading from the old version of the Constitution, because a lot of people getting mixed up and coming to me with some things. I mean, I said, stop reading from the old version of the Charter of Fundamental Rights. In 2011, that element was amended by virtue of the 2011 amendment of the Charter of Fundamental Rights and Freedom, Constitutional Amendment Act. Section 13, don't remember the exact subsection right now, conveys, if someone is here, you can let me know, conveys a constitutional right, or preserves or gives a constitutional right to every citizen for protection from search of person and property. No, the Constitution does not define property. In the US, can we have some people who like to say, you think a US this? Let me tell you something. For those of you, or those of us on here who follow law, read case law, know and understand the law, and even practice the law, if you read the Jamaican Constitution and the provision that gives protection from search of person and property, it is a stronger worded law, constitution, than the US Constitution. And if you look at the provisions in the Jamaican Constitution on a whole, our Jamaican Constitution, the rights given are worded more strongly than in the United States of America. So when some of you like to say to me, for example, you think of US this, let me tell you this, me not think of US, me think of Jamaica. Me know Jamaica, we have strongly worded constitutional provisions than the US. So if you think the requirements in the US are justified, you better know say Jamaica even require more. Is there anybody here who want to disagree? Yes? Is anybody who want to disagree? Our Constitution, the Charter of Fundamental Rights, is worded far more stronger than the United States America Constitution. You think the US Constitution have a freedom of movement provision in it? Think again. No. It's the Supreme Court that assumed that into the Constitution. But for the Constitution, recognize freedom of movement, separate from the right to liberty. To show you how strong our Constitution is. That is a fact. Go and research it. So, in the US, the Constitution, come here compare now, come here have another naysayers. In the US, the US Constitution says something like this. Every person has the right to protection from unlawful search and seizures. You hear what it says? Sorry. Every person has the right to protection from unreasonable, that is the right word it used, search and seizures of property. Our Constitution in Jamaica, in section 13, on the contrary, says every person has the right to protection from search of person and property. It never say unreasonable. It's a protection from search and property. That US say unreasonable search. Our one say search from person and property in plain language, which means unreasonable and otherwise. Let me pause there for some of us who want to research. Yes? Thank you, Baker. Yes. Yes, Dre, miss you. All right. So continuing. Our constitutional rights to protection from search of property. Anything on the city US law, court case law say, because we don't have no word for case law on these constitutional provisions, you know. But may I tell you now, and the attorneys who are on here can back me, tell me if you say, yes, I agree, Mr. Dunn. Yes, make everybody else can get it. In the US, if you think that the police cannot search a property without reasonable or probable cause, because the Constitution in the US protects some unreasonable search of property and seizures, then in Jamaica, them need reasonable probable cause and even more based on our constitutional provision. And now we get into when your right to protection from search of property may be infringed on. The Constitution set out in clear language. It says, save as may be demonstrably justified in a free and democratic society. Next part. Parliament shall pass no law, and no organ of state shall take any action that infringes on these rights. And I may say so. A Constitution. Now, we're talking about the right to protection from search of property. So, property, we look at the phone where I get to. I build up to the phone. So then, What does demonstrably justified means? It is a whole test that the court have when they want to assess whether or not a law or an action by an organ of state is demonstrably justified in a free and democratic society. That test is called the Oakes test. And for the life of me, for the Azad people, whether I try to discredit all of what I'm trying to teach you, the public, the Oakes test is a standard test. No matter if I have a different case law, case with different situation, the Oakes test is the Oakes test, and the Oakes test is the standard. The standard has a, we can't go through them all tonight, but one I like to highlight is simply this. Simply this. As long as there is a less intrusive way to infringe on the rights guaranteed under the Constitution, then in the law and or this action taken by the organ of state is unconstitutional. You know what I mean? Because these are rights we are talking about and not mere privileges. No, the parliament, the law, and the organ of state have to make sure, say, they might do the very least to infringe on the right. Not the most. Not the most. So if there is any less intrusive means, for example, just like I talk about the stop on I want to search of documents. And for those who don't remember that inspection examination is a search. Hemans versus Attorney General what is the case law that confirmed that. To examine your documents is a search of your documents. All right? Anyway, continuing. So, Parliament can't pass no law and no organ of state. It's a separate story now, you know. Law is there, but the organ of state shall take no action, as the Constitution says so, that infringes on any of the rights, save as may be demonstrably justified, save as is demonstrably justified in a free and democratic society. And I have said to us many times that if you want to know if something is demonstrably justified, just put this point. The action must have, the person who is taking the action will require reasonable or probable cause to take the action. That's the most simplest way you can tell if it's the action taken is demonstrably justified. Now let me bat with some of the people who know why naysayers again. The Road Traffic Act is just a law, but the Constitution say Parliament no fi pass no law, and no organ of state no fi take no action. A two things say no. It's say no law no fi pass and you no fi take no action. So when you now come and go and tell me say Ila no say any the reason or problem because the Constitution say if you're an organ of state, you are not to take any action that infringes on a right. Not telling where I say, can I put a duty on you too? You know if you take no action that infringes on the constitutional rights unless it is demonstrably justified in a free and democratic society. What does that mean for phones? What does that mean for cell phones? Anybody want to tell me in the comment section? It means, by virtue of the Interpretation Act, your phone is property. The Constitution never said that protect personal property or property you own 10% of, or property you own 15% of, or property you have 100% interest in. It never says so. It says it protects from search of property. It never said property where you have only 5% interest of. If you even have 5% interest in it, it will protect from search of that property. The Interpretation Act defines property as many things, including any description of property or an interest in it. So the people, for example, like we say, driver's license are property, and a fair property, a government property. Half your property. The Constitution protects from search of your driver's license. It search, examine. What happen when you examine something? No search, I search it. Come on, man. We can't understand some people in logic. When your doctor is examining, what am I do? The search must search something. How is examination not a search? Search is a broad term. Examination is one way in which something is searched. Basic English language. Yep. So, continuing. The Constitution protects some search of property. The police can search your property. There are many laws that gives the power to the police to search property. All of them, as far as I can see, requires the police to have reasonable suspicion or reasonable probable cause to do that search. All of them. Examine is search for your name, your address, your date of birth, etc. Examine to try to identify you. That's what they do with a driver's license. It's not just even to just prove that you have it. It's also to search for your name, your address, your telephone. Just imagine the police random Mr. Benson, Mr. Driver, let's ask you, sir, is this your correct? Do you still maintain this address here? You know, no, you know, move here. You just here run up in now. It's an offense. Your address need to be updated on the driver's license. Anyway, continue. So, oh God. So, your phone is described as thing, as any description of property. Your phone, you have an interest in your phone, which makes it property, which gives it constitutional protection from search. Parliament has passed laws that gives the police a power to search your property. What do those laws require? Reasonable suspicion. And that's unreasonable or probable cause. Reasonable probable cause for what? To suspect that the phone has been used or is being used in the commission of a crime. Then them can get access to search your phone. But that cannot, Mr. Them can get access, Access, how? By way of a warrant. Even under the Latches Scamming Act, there's a need for a warrant to search. That's how the guy got away the other day. After they find everything. No warrant, no prima facie case. The law requires that before you can search under the Latches Scamming Act for Latches Scamming paraphernalia, the constable must obtain a warrant. And that warrant can only be obtained if their prima facie case is made. Forget some of the time that not everybody on here understands the legal language. Prima facie case is saying that you have to make out a case that may not be so, but it appears to be so to a justice of the peace. It may not be so. Yeah? But on the surface, it look like, say, it could be so. With evidence. So you present the evidence and say, here is a man who has visited that house 10 times. And he has a testimony, sworn testimony to say that is so. And because of that, you're saying, well, if a man who visited that house 10 times, then that man might be true. So that's an example of a prima facie case to get a warrant to get in there. And yeah. And it's a credible person, so on and so forth. So the police go get a warrant by convincing a justice of the peace that they have a prima facie case. Otherwise, if they don't present a prima facie case, again, on the surface, if they don't present a case on the surface that the person might be guilty, is probably guilty to a just of a peace. In other words, a GAP have to try the case first on the surface and then issue a warrant. And then search can happen. Or you can do what the Constitution says you can do in its intent. You can waive your right to all of that and just say in. Or you can do what I know many people do. What is that? You can acquiesce the consent. Acquiesce, go Google it. Some people pronounce it acquiescing. Acquiesce is the legal terminology for silent mean consent. If you have knowledge, acquiesce in law is like this. If you have knowledge that someone is going to do something, and while being fully knowledgeable of it, that the person say, I will do this, and you do not protest, you remain silent, you under the common law, under the common law, you can be considered to have acquiesced, consented to the thing. Okay? Acquiesce are called acquiescing. Just Google it. Yes, that's it. Acquiescing, acquiesce. Yes. They pronounce that Jamaican language acquiescing. But when you're in there, say acquiesce. You have a quest, you know? That's how you argue that part. All right? So that's the legal terminology for silent mean consent. It happened in land law too, where somebody build the boundaries are shifted, but it's really it takes 7 years in that case for acquiesce to happen in land, where somebody. That's why a lot of fearful here, because anybody can thief land by any way, legal means. A man cannot shift a boundary fence, and if you shift a boundary fence in your full knowledge for 7 years and you do nothing about it, the law says land is no longer yours. I feel that man know. The man just shift a fence by a little. Shift it and fame land as well. So, yep, that is the law. That is acquiesce under the Limitations of Actions Act. Anyway, proceeding. So, gentle people, faithful viewers on here, on YouTube, and also on TikTok, the police has a power to search your property, your phone. They have a power to search your driver's license. But that search must be demonstrably justified. In a free and democratic society, the action of doing the search must be demonstrably justified. The law that gives the power to search must be demonstrably justified. Even if the law gives a power to do something, the agent of state that are the organ of state that is activating that power must, the Constitution put a burden on them. Even if the law that was passed not put it in a plain language, the Constitution imposes a burden on the organ of state, my naysayers here, to have demonstrable justifiable grounds, reasonable or probable cause, the most basic of it, to infringe on a right. So all if the law not says so, you, the agent of state, has a burden separate and apart from the law that Parliament passed. You know, one of the only reasons why they make the laws that, one of the main reasons the laws are there, separate and apart from just you taking action that is demonstrably justified, because the Universal Declaration of Human Rights, which even the JCF Public Interaction Policy acknowledges that the police must respect, separate and apart from our Constitution, that Universal Declaration of Human Rights states in it that the rights guaranteed, not this exact word, may only be infringed on by way of a law. First thing, by way of a law. And that is one of the reasons because our government is a signatory to that. Yes, for because our government is a signatory to the Universal Declaration of Human Rights, then obviously they have to comply with that. All right, and the agent of states have to also comply with it. So there is a law that was passed that allows the action to be done, and that is also falling in line with agents of that creatures of statute can only do what the law expressly says that it can do. All right. The JCF has the power to search your phone, but they can't just take it from you and go in ISO. A week ago, I mentioned people using facial recognition as their way of pulling their phones. If the policeman, not go over that. Anyway, not going there. So if you, if you, the police can search your phone, the police can search your property, but the standard is they need reasonable or probable cause at the very least. And if they want to search the property, such as your driver's license, which is property, they must have demonstrably justifiable grounds. As long as there is a less intrusive way to infringe on the right, and I will repeat for emphasis here, detecting an offense or hearing that there is an offense that might have been committed is a less intrusive way to violate the freedom of movement than to randomly stop a vehicle to check the documents if they're up to date. There are several case laws that go to the Supreme Court in the United States that agrees with this. Several, just go Google them. That arbitrary stops are unlawful. There is also the common law provision, the common law, that says, just look at the case of Jamaicans for Justice versus the Police Service Commission, 2019, the the JCPC, paragraph 23-24. The Privy Council reaffirmed that it is the common law that arbitrary actions by any agent of state is prohibited by under the common law and is also prohibited by the Constitution. And there is no law that says the police can take any action arbitrarily. So you have to see it written in every statute. All right. So again, unless you volunteer your phone over to the constables for them to dig in it, they have no right to get in there. If they want to get in there to search it, they must have a warrant. That is the law. Or you give them consent to go in there. To get a warrant, they need reasonable or probable cause. And that means, in plain language, they need an honest belief in your guilt, founded on reasonable grounds, that you are probably guilty of an offense. I'll take questions and anybody who wants to join. We have 9 minutes to go. Questions? All right, how do you sue the government for bad roads? Why? Government, me not help. Me not really send nobody to sue you. All right, there is a... All right, here are the legal principle now. There is a principle in law called... One second. This will come back in my head. It's called... Hold on. This will come back to me. It's shifting. There's a way to do it. There's no law. There's no written law. There's a common law provision. It's... Oh, goodness. It has eluded me. All right, give me 1 second. I'm going to answer that question. Chad, wait. I saw answer the question. 1 second. Excuse me. Chadwin and Company. All right. So when I see a bad road and a something, it's not a written statute. You see, if you drop in a bad road and you mash up something, it's called misfiance. That's how it's pronounced. Misfiance. Yep. Misfiance. That is the word. You know, it elude me. It's you see, knowledge is power, you know. If you don't know what to search for, you don't know what to search for, you know. And you could have Google till God come. If you don't know where you look for, you can't find it. So you have two things called misfiance or malfiance. Yes, I understand. Misfiance, great. So then, so that is the angle that you get that. So basically, the principle, the common law principle of misfiance, malfiance. Anybody want to hear my pronunciation? I'm here. Is pretty much the agent or the public body who is not conducting their operations in a lawful way. Yes. So that's the angle that you can take towards recovering damages in that respect. There's also another way, as far as I'm concerned, that you can approach um, that case, because there's case law from our Supreme Court. If you want the details on that, Chadwin, and anybody else, you can ask. But I can send you the case law. I don't remember the citation right now, but I know where to find it because I've seen them, right? But there are case law where people have succeeded in using the doctrine of misfiance um, to claim for damages and dropping a patrol or something. Yep, because the state of a duty, even well, I don't think negligence doesn't work under the it didn't work. So it's misfiance that the person had to take that approach, because negligence didn't work. Because if there's no duty of care under the statute on the roads, etc., then Chadwin, inbox me so or anybody else so I can remember that you want that. All right, but that is the angle that you take, misfiance, so on and so forth. But because negligence don't work, I've never seen negligence work in any case at all. All right. Any other question? YouTube or TikTok? Can a health inspector can search my business place randomly? Well, health inspectors, I don't know health inspectors coming anywhere randomly to search anywhere, but it's the same constitutional right to protection from search of property. Yes. The thing is, health inspectors have the power to search, but like any other search, it must be based on reasonable or probable cause. So then don't just get up and just come search. No, them get up and search because they had reason to believe that it is whatever. Yes, an offense has been committed. Your place now keep good or something. So, but they can search. Any other question? Any other question? Any other question? Can we remain silent when pulled over without a reason? Oh yes. Ha! This is not used. This is not used, but I have alluded to it before. You have the right to remain silent. As under the law, under the judge's rule. That is what it is called. It's a common law, the judge's rule. You, as long as the police have a reason to believe you have committed an offense, you are, as long as they have a reasonable suspicion of it, or they have in their mind that they're going to charge you. The judge's rules, which is a law, dictates that they have to remain. You have to be ready, right to remain silent, and told that anything you say or do can be used against you in the court of law. And I will tell you, anything you say or do can be, if I even say a name, can be used against you. A joke, we have to say a name still. The police has to be giving your name, your address, and your date of birth. Yes. No, man. The judge's rule requires that the police caution you by telling you your right to remain, reading your right to remain silent. Yes, it does. Yeah, those are Miranda rights in the US, but we call it caution in Jamaica. It's called caution in Jamaica. So the police is required to caution you at the point they have enough information to arrest you or charge you. All right. Now, I'm going to slightly introduce tonight, and then we'll go on it with more in another live. False imprisonment. And this might be the shocker for the night. False imprisonment under law is a common law provision, common law thing. False imprisonment is defined as the arrest or detention of someone without their consent and without lawful justification. Guess what happened when the police randomly stop you now and both them are asked documents? Who can tell me? Come on, my eye. Who can tell me? Just send a message. What that amount to by definition? Somebody tell me, man. Can I wait for it? You know, we are talking about police guy in prison over 74. You think I SOE this? I know SOE this around unknown. Anyway, we're looking at the new Bail Act, the Bail Act that was amended. Yes, it's an unlawful detention. A stop is a detention. As when the police put up the and as a stop and detain you. Remember the last, you know, if the police say you must stop, you know, stop is an offense, you know. Just not to stop is an offense, you know. So then even a stop is a crime. You commit by not stopping. So we are tell me say I go fish. So even the people who want to try back stop for documents. If me don't stop you, it's an offense. A crime me commit. So you tell me say you are gonna just go to the road, go just say, let me play upscotch. Let me see who are gonna stop and go stop and commit crime. Eh? Just without cause? You're gonna use a power? Come on, guys. Every angle you take it, a random stop to check documents can't lawful. Because a stop by the police is a detention. It's not an arrest. It's a detention. We get it? A stop by the police is a detention. And if you're going to detain me and tell me, say, when I say, a reason to stop me, VCP, spot check. That is false imprisonment. We following? Thumbs up if you're following or something, guys. Send the interaction, man. We can know you're following. Send the thumbs up, make we see you following. So that amounts to false imprisonment. Clearly so. And you can get a lot of money for it, oh. Anyway. A lot of it. That is why you have to object. Can you hear how the tort of false imprisonment is defined? An arrest or detention without your consent and without lawful justification. That is false imprisonment. What that means, say? That is why I don't always hear me out there. Me no consent. Me standard, me don't even say the words I do not consent. As long as in the interaction I'm there and I'm like, you're infringing on my constitutional rights. That is me telling you something. I consent to what I do. I don't need to use the words, I do not consent to any search or seizures. I don't need to have to use that. Yep. That is false imprisonment. A stop is a detention. You are detaining me for what? For see if me have a pass? For see if me have an ID? For see if you're going to use a coercive... one of the most coercive power the police have, arrest and detention. You're going to detain me just to see if me commit one other crime. And you never have no suspicion say me commit it. And a free country this. If I saw you go. Can't be. can't be. Gentle people, if you have no other questions, the next live is scheduled for Saturday at 7:10. The topic will be announced. I'm looking to get a guest on with us. Tell a friend to tell a friend. Done Out the Law will be live at 7:10 p.m. on Saturday. Again, with more knowledge to share. By the way, where Inspector Brian has an update, where Inspector Brian is concerned, today, minutes after 5, I got confirmation that the matter has been assigned to another inspector at IPRO. They did not send it to someone else. So the matter has been assigned. The investigation has begun. Now, in a civil matter, the ticket is still not in the traffic management system, so I'm assuming that won't come up. The civil matter that I intend to file will come, but I want to see how this investigation unfolds. I have the lawsuit drafted and ready to go. Any questions? Any other questions? If there are no other questions, we have exhausted the time I have scheduled for this today, and I will see you again on tint. All right, you see tint? Tint require a tint meter to measure it. The last time I checked, we don't have the meters in the country, so that can enforce. If there are no other questions, you have been a great audience. Another exciting topic to come up. We'll elaborate on all the things that we have discussed so far. Get clarity. You have been an awesome audience. The naysayers, the ones who are not agreeing with me, I hope you have more clarity now. Yes? And if you don't, then come back here again on Saturday at 7:10 p.m. We'll be live on YouTube and on TikTok simultaneously. Thank you very much. Have a great rest of the night.